Okay, we are live.
Okay. Good morning. This is Senate Judiciary, January 20th, 2023, and we're taking up S4, an act relating to crimes of violence associated with juveniles and dangerous weapons. First witness is State's Attorney Erica Mothage from Bennington County. Welcome, Erica.
Thank you for having me. I just wanted to see, I know you have a busy morning and you have a lot of witnesses. So I just wanted to touch on the things that I think were particularly important from my perspective and from the perspective of prosecutors on these cases. First of all, we would support S4. I think it's a good bill. I think I support the administration's comments that were made last week. I believe it was last week by Jay Johnson. I've also reviewed some proposed language that she had prepared, and I think that addresses some of the issues that I'm about to talk about. So what I think is important and valuable in S4 from our perspective is going to be the ability to direct file cases as youthful offender in criminal court. And this would be why, really. Anyone who's been on the committee for the last 10 years knows that I've been talking about youthful offender. It's an important sentence structure to me. It's something that I've been using well before it was even part of the statutory authority. We would kind of put it together unofficially using two courts. So the reason that I think we need to have the ability to direct file is not what I think some people would assume, which is so that I can just direct file a bunch of juveniles in criminal court. It's so that I can get the process going quicker. It is contributing, there is no question, these cases are contributing to the backlog in both family court and criminal court. The cases that I can think of right off the top of my head, I was talking with Tim about one of them this morning that, one of my prosecutors has been working on it for probably 18 months. And that's because there's this administrative dance where we have to go file it in juvenile court, transfer it so that we can get file a motion for youthful offender, transfer it back. And you have to remember, in the logistics of this, there are two courts, two different judges, and two very different schedules. And I don't know if anyone, I'm assuming a lot of folks have had surgery, right? And you are dealing with, if you need an appendix removed and you need something, some skin thing done, it's two different surgeons and they're working on how to schedule. It always occurred to me that why can't we just do all of these things together? And what we hear is, well, it's the schedule. So juvenile court in Bennington is on Thursdays. Sometimes it's on Fridays, but criminal court is every day. And certain days are scheduled for certain events. And these are considered motions. So they are sent, they are put on a day that is already completely overwhelmed with motions for anything dealing with civil suspensions and motions that have absolutely nothing to do with.
Can I just break in just for a second so
Yeah.
the committee knows what you're talking about? We did get a document from Jay Johnson yesterday. Eric did. I don't know if it's been posted, and I don't know if the committee's aware of the proposal. She did outline it. It's not. So what you're talking about may not be, it's fine to talk about it, but I just want to make sure you understand the committee as a whole. I did get to review it yesterday and this morning, and understand. I think what's in it is, but I don't understand. But the committee
So
hasn't seen it yet.
So I'll just
So
couch
just
it
so
like,
you're aware of that.
yeah. So I'll couch it like this. When you get that document, that's
Right.
absolutely one of the major problems that we have with the structure that we have now. So we get a case. We'll have an 18-year-old that is charged with, say, either drug trafficking or human trafficking, or even let's say it's a 18-year-old that brings a bomb to school. Those cases, they have to start in juvenile court, which gives us very little by way of conditions, bail, things that help us with protect the public. They are the cases that contribute to this issue that you've been hearing about all year with 18-year-olds that are being put in DCF, technically, not their custody, but their DCF's responsibility. DCF is being required to find a place to house a violent 18-year-old. Those are the cases that this would address. It would allow us to make the decision not only to streamline the process, make it more, the access to justice right now is ridiculous because we have, the parents or the family members of the 18-year-old that are getting hearing notices for juvenile court, criminal court. Some of the cases are, that can be filed in criminal court, say an aggravated assault is filed in criminal court, but 2 or 3 other matters need to be filed in juvenile court just because of the statute. So we'll have an individual that literally will get a hearing notice and need to be in court on Thursday for, a bunch of misdemeanor things that were part of this one affidavit. And then they have to come back to court on Friday. Now, a lot of our counties border other states, particularly what Bennington is seeing quite a bit is folks that are coming here from Massachusetts. So we'll have individuals that are, they're not getting the whole picture of the court process. You have family members that are coming and they're hearing from 2 different judges. They're hearing from 2 different attorneys. That's the other piece of it that is pretty important, where they're not getting treated as a person, as the whole person. And that's exactly what youthful offender and juvenile court is supposed to be doing. So if we're not making that process accessible to all of the individuals that fall into that category, then what's the point? It's just creating a bunch of background noise and a bunch of extra court appearances. It also prevents something that I've seen lately is when we have an 18-year-old that's charged in juvenile court, the police write their affidavits to provide probable cause for that individual. So the juvenile in juvenile court, there is an affidavit of probable cause attached to their case that judge has read. That's the judge that's making the determination about youthful offender. That judge is completely unaware of all of the affidavits of probable cause that have been written about the co-conspirators or the co-defendants. So we have a significant number of young individuals coming to Bennington County from Massachusetts that are engaged in drug trafficking with older relatives. It seems to me that the judge that's making decisions about youthful offender and treatment going forward should be made aware or be aware of the co-conspirator individuals. And the affidavit, and you may say, yeah, well, they are because they're going to be in the affidavit. It does not read the same because that's what the probable cause affidavit is supposed to do. It's supposed to lay out the case against this individual. It doesn't include all the mitigating factors. So when I've had cases that go to youthful offender and they're in front of a criminal court judge who has seen 4 of the adult co-conspirators that have come before that 18-year-old, they have a much better picture of how this 18-year-old ended up here. And I think that's a really important piece that's lost in the process we have now. Judges do not have time to read all of the affidavits from all of the other cases. In 20 years ago, we used to have the judge would just say, okay, I'm going to put on my juvenile hat or I'm going to put on my criminal court hat and read the paperwork from the other case and talk about it on the record. They don't do that now for a few reasons. They don't do it, and I see Marshall shaking his head. We don't typically agree about things, but I am in juvenile court every week for the last 20 years, and they do not read the affidavits that are being filed in the criminal court case. They look at the DDRs, they see what the conditions of release are, but they are not seeing that person in the courtroom. More importantly, they are not hearing what that person is saying in the courtroom. So the fact that we have such a new bench now, there are very few attorneys that are experienced enough very few judges that are experienced enough at this point where they're willing to look at these other files while they're sitting in court making decisions about things. I also run into a fair number of attorneys that do not understand what a youthful offender status is. So that makes it difficult because they're not presenting the appropriate information. So I think S4 addresses a lot of this. It definitely, Jay's language, you'll see when you get it, addresses the violation of conditions of release. I can literally have someone in family court that is transferred up, is in criminal court, has a condition of release. They get sent back down. They get a criminal court condition of release. They get sent back down to juvenile court, and they violate that condition in a substantive way. And there's nothing, it has to be filed in juvenile court. So what does that do for public safety? This is really the issue. To me, I see the kind of depths of the impact on the individual offenders. But when it comes to public safety, there's no question that the way it is written now, we have no ability to protect public safety when we're dealing with 18 and 19-year-old violent felons that are coming to Bennington County. And I can't speak for every county, but I know Windham is having a similar issue. I mean, does anybody have any questions? I know not everybody looks particularly enthralled. So
no, it's not that, Eric. I think first of all, we need to post Jay's memo, if that's possible, so that the committee has copies available, because we haven't gone over it yet. She did present it in conceptually last week, I think it was, but we haven't really gone over it. And I do plan to do that on next Friday, a week from today, if Peggy can arrange for it. I do have one question about youthful offender and the status, the requirement in Jay's memo, which would require a conditional plea, which is one of the things that resulted in the lack of use of youthful offender in places other than Bennington County previously.
Yeah, that's a huge, that's probably the single biggest issue that we had when youthful offender came in, and here's why. You have somebody who, I used to use youthful offender all the time particularly for offenses involving a sexual assault, some type of sexual offense. If you have an individual that is not taking a conditional plea, that means that individual cannot go through any kind of treatment. We need to have the sexual offender treatment is very specific, that you have to take responsibility and you have to acknowledge the offense you were charged with. So when you have an individual that is sent to youthful offender, but it is not a conditional plea, now we're starting the merits hearing in juvenile court months and months and months after the offense happened. And here's the biggest problem with that for the actual offender. You can't do any of the treatment that is intended for youthful sexual offenders because you're going to age out. We're not even going to get to merits before the person ages out of the population that is allowed to do youthful offender sexual offender treatment. So that means we're going to have to put them in with adults. So that's just one issue with it. There are many others.
But I understand that. I understand from your perspective, from the Defender General's perspective, it's the reason that youthful offender was used so little and will be in the future. So it's kind of a struggle there.
Yeah, I mean, but the whole, if you recall back to when the entire youthful offender statutory process, when we started going through that, a major part of it is the amenability to treatment. Mm-hmm. So if you have an individual that's saying, sure, I'm amenable to treatment, but I didn't do anything wrong, which we regularly have happen in these youthful offender hearings. And my deputy Jared is on the phone. He's done a number of them lately, and that's what we hear. Yes, oh, sure, I'll do treatment, but I didn't actually do anything. So to me, that's fine. If they want to indicate they didn't do anything, that's fine. But a youthful offender treatment is a benefit that adults, people over 18 years old and now over 19 years old, are not getting. So that is a consideration that requires buy-in. And if you have an individual, a youth, that is just not buying into anything that is, then, that begs the question, well, why would they need any youthful offender treatment if they didn't do anything? The plea is conditional. We never had an issue with it in Bennington. We never did. It was regularly used as a sentencing tool. The reason we don't use it now on a number of cases is for that very reason, that if we're going to have a merits hearing and a contested 2-year list, be on the trial list for 2 years, why would we, try to treat somebody as a youthful offender if they're going to be 22 years old when we're done? Because that's what it amounts to. We have individuals that'll turn 21, 22 years old, and they can't be treated by anything that DCF would even remotely have to offer.
Are there other questions for Erica Mathage? You didn't mention human trafficking, but can you describe that's part of the S4? Can you describe what you're seeing in court in terms of human trafficking in Bennington area?
Yeah, we're seeing a couple of different things. And it's really an interesting dilemma because, I would argue that some of the individuals we're dealing with are, they otherwise would be just addicts, right? They have substance abuse disorder. They're being forced to run drugs for the provider, for the individuals that are coming forward. We also are seeing a lot of folks that live in their apartments. They have made maybe a purchase of drugs or heroin from someone from Massachusetts. And then the next thing you know, someone is showing up on their doorstep saying, I will provide your supply of whatever your drug of choice is, but you have to let me stay here. And then they're refusing to leave. And then the third situation we see is there's an inordinate number of women being sex trafficked in Bennington, women that are also suffering from substance abuse. They can't, they won't talk to us because this contingent that we were talking about, this young, violent contingent, is just not being addressed in any meaningful way. They get arrested, they come to court, they're immediately released, and they're immediately gone back. So our victims in the human trafficking are saying, I'm not talking to you because there's nothing you can do. And Cam could speak to that more, but that's essentially where it's at. They're saying, I am more afraid of these violent individuals that are in my apartment than I am of you, and you can't help me. So it really makes it difficult. And obviously, I think it begs the question of the young offenders, right? The 18, 19-year-olds.
Mhm.
I don't think they're choosing to go into this, business. They're also being brought along by the older dealers, but they also can't, get out of it. And when we have a lot of the individuals that we have had in that age range, the 18, 19-year-old, they have family court cases in Massachusetts. A lot of them are on supervision in Massachusetts. So, but some of them have been in foster placement or have had significant home issues before they came to Vermont. And so I think it's just a really complicated, multi-level problem. But I don't think it's possible to deal with it in these individual silos that we're dealing with it now. If anybody remembers when we did the domestic violence court in Bennington, the whole point of that was to make it a whole person approach. This is what youthful offender is about. We should be looking at everything, their employment, their living situation, their families. And we can't do that when we're doing some of it in criminal, some of it in juvenile. The two judges are two different judges, two different lawyers. We need to get that synthesized so that we're really dealing with the whole person.
If the vice chair would kind of take over if there's questions from the committee, I'm having a hard time seeing the committee members.
Sure thing. Any questions? Thank you, Eric. Is there anything else that you wanted to conclude with, or should we move on to the next witness?
No, I want to make sure that you have time to hear from everybody. So
thank you for your testimony.
Thank you.
Thank you. If you want to join us on Friday too, informally, we're happy to provide Zoom information for you or Jared to see, as we go over the administration proposal in more detail.
Okay.
If Peggy can put that on the agenda, and if Eric is available and others are available. With that, Matt Valerio, I think you're next in the witness. Or is it changed?
No, you want to listen to everybody again? And
no, not with this one, because this is much more complex, and you'll see kind of what I hope we can do with it. I'm Matt Valerio. I'm Vermont Attorney General. This I'm always interested in Erica's testimony regarding what goes on in Bennington, but this is one of the things that I think we have to be wary of. Is that Bennington is one small part of the state, obviously a very important part of the state, but a lot of the things she points out are unique to Bennington. Issues of lack of resources for treatment for people who get into youthful offender, how the dynamic of what's going on in that corner of the state as far as people coming from Massachusetts or New York into that particular corner, how it's addressed, and also how it's addressed by law enforcement and the state's attorney's office. I do think my office has some disagreements about the generalization of what's going on down there. But what I'm going to suggest, first of all, I've obviously gone through the bill, and this bill is kind of like a stew. It's it kind of shotguns a bunch of different issues that don't seem to be particularly related to each other. Although I guess you can always tie, the criminal law together in some way. But I've got people within. I could, talk to everybody, come in and give you my, finished stew version of what goes on. But this bill and the issues that are in it, I think, are most appropriately dealt with by kind of the experts that we have, at least in my office, separately. So there are a number of gun issues in this bill, and Rebecca Turner is kind of our office expert on the state of the law regarding firearms, the Second Amendment, and where that all stands in light of Bruin and a number of other cases that are around the country from the various circuit courts and even district courts on the federal level, which now seem to be driving this area of law. I mean, we have seen with Bruin coming and other cases that are following it, the whole kind of paradigm in dealing with Second Amendment issues has changed. And what might have been obvious a couple of years ago is completely either flipped on its head the other way now, or totally murky, and we don't know exactly what's going to happen, and we're waiting on cases to make their way through to the Supreme Court. So Rebecca from my office will be, I'm going to ask you indulgence to have us have her deal with those particular issues, because she's the real expert on that. Marshall Paul is the chief juvenile defender and has practiced in juvenile court for his entire career all around the state, not just in particular counties, and has been the chief juvenile defender for how long? Seven years now, and was working in the juvenile defenders under the prior chief before he did that, and was instrumental in getting the changes to the youthful offender statute put through when they were a few years ago. So he's familiar with the way things were before. He's familiar with the way things are working now. I have procedurally, I agree with some of what Erica said about the awkwardness of how the juvenile system works. In my own mind, when it comes to youthful offender and other issues, but youthful offender relative to this bill, I always had the perception, because the court at one point became a unified court system where a superior judge has the same jurisdiction, whether a family court judge or a criminal court judge or a civil court judge, all of those judges sit in all of those courts. I remember when I was first practicing in Vermont in the late 80s, we would be in a criminal court, and then a juvenile situation would arise, and they pull the shades on the court, they send everybody out. Now the then district court judge, who was criminal, became the juvenile court judge for purposes of what was going on there. When I saw this originally come through, my concept was, that's what's going to happen here. We're changing the status of the person, from being in criminal court to now being a youthful offender. But we didn't need to change the judge, and I didn't even think we needed to change the lawyer. You just then continued to argue the standards that would be there for youthful offender. Marshall can talk much more in detail about that, and I do agree, and I think my office agrees, that there is a procedural issue with the way all of this happens that adds unnecessary delay and work for the lawyers and the court involved. But he is the expert on that, and I'm going to ask that the committee allow him to really testify and carry the ball for us on those issues. I, of course, have to be an expert on something. And the biggest areas that I can talk about is, you have the section 2 involving dwelling and building owners from recklessly permitting premises to be used for human trafficking, selling, dispensing of regulated drugs, and the like. I can tell from personal experience, having owned many apartment buildings over the years, I can talk from my own personal experience and one particularly scary experience from my own past, but also over the years that, before I was Defender General, I represented, the largest land owners and property owners in Rutland County, and who had apartments all over the place, and some of the issues that arose there. I think that this kind of thing, inferring knowledge of activity that goes on in apartments, is very problematic, and it's something that you have to. It's a problem for me, and I can talk about that at length at some point. I also am.
If I could break in, Matt, and just explain where this is coming from. So you have an apartment building, say 10 tenants. 9 of them are upset and contact the landowner about what's going on in one of the units. The landlord does nothing, and yet the behavior continues. These people may not have the resources to move out of the apartment that they're in, or the police aren't able to do what they need to do. And this would simply hold the landowner, I say simply, and I understand why it's complex, but the goal behind it is to hold that type of landlord accountable for not doing anything for the other tenants if they could have. It's not designed to say, well, there was drug dealing going on in that apartment, you should have known, and blah, blah, blah.
Yeah.
Just so you have a general understanding of where that came from.
Yeah, that concept is flawed. The issue here is that
The concept is flawed.
well, the concept that the landowner can do something. Take a look at Vermont's eviction laws and see what you can do to get somebody out who's been continually paying the rent over a period of time where you have no direct proof of anything going on, although somebody tells you that there's drug activity or some other illegal activity going on. I don't know what do something means. Does that mean self-help? Does that mean going over there and, throwing all their stuff in the street? Well, you can't do that. To go to court, you have things you need to prove to get an eviction. I guess I'll just tell you the little story that I had, and I would never have known. But, before I was Defender General, I did a lot of criminal defense work and the like. I also owned some apartment buildings, and somebody from the Southern Vermont Drug Task Force came to me and said, hey, do you own that building on so on and so forth? And said, yeah. I said, well, we've been surveilling apartment number blah, 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 because we think that there's, drug sales and the like going on there. I go over there and I'm like, oh, geez, that's not good. And I said, can you tell me who? Oh, no, can't tell you who. Can you tell me when? I can't tell you when. So you want me to go over and do what? Well, I'm just telling you that there's drug activity that we think is going on over there. So I actually hired a private investigator to do the same thing that the cops were doing. And what we seemed to think was that there was a son of there are 2 elderly tenants there. The son had got mixed up in opiates, and they wanted him back. They basically like, come home and we'll take care of you. We'll get you off the drugs. And meanwhile, apparently he's selling some drugs from the apartment there. He's living with his elderly parents. I go over there and tell them, I said, he's got to get out of here. And there's nothing we can do. We're kind of afraid of him. We're afraid of the people he's bringing by. And I'm like, I don't want to run into a problem, obviously, with the cops. And, we got to do something. But I can't evict them. I don't have any basis to evict them. The son is doing what he's doing. Ultimately, personally confront the son. He denies everything, of course. There's a sad epilogue to the story. I don't doubt that the kid was involved in doing drugs because he overdosed and died in the front apartment bedroom there, and that kind of ended the problem. But from a landlord's perspective, what was I going to do? What could I do? So to say that the landlord is doing nothing, the landlord's hands are often tied. And this is, when you're trying to put liability on a third person who is not the bad actor, that is problematic. And I think that you're going to run into some significant issues with a lot of constituency groups, number one. If you want to do something with the landlord tenant statutes that allows, self-help, if you find out that somebody is, dealing drugs out of your apartment, or some kind of expedited summary procedure that says, we believe, or we received information regarding this, and as a result, we need an immediate writ of possession and order executing the writ of possession to evict the people from the premises. Well, then there is a legal thing that landlords can do to address the issue. But I don't know what a landlord can do at this point.
Yeah. Can I, so I appreciate all this testimony, but there's part of it that I kind of have to push back on just a little bit here. I'm, going back to a few minutes ago, telling a landlord, let's say there's an apartment building with 3 units. You have a landlord who is living in another state and, has a property management company. One of the tenants reaches out to the landlord, says, hey, I think, or I know somebody is selling drugs in the apartment next to me. Can you do something about it? Just that by itself, and then just that by itself, certainly doesn't rise to probable cause to charge that landlord. But I think there's a distinct difference between that situation and somebody who has a house or an apartment building and is intentionally using different units, using different people, and exploiting those folks to sell drugs, to use drugs, and to do criminal activity. So I feel like there's 2 distinct situations there.
Well, there is, but there are 2 different words in that this proposed bill talks about, which is knowingly and recklessly. I think that, frankly, if they are knowingly using the premises, they're part of a conspiracy. They're at least an accessory, and they're profiting from it. That's different than being a landlord who has gained knowledge that these things are going on, and all it requires is the knowledge. I think you got to give landlords some tools to actually get people out. And I think you have to make sure that the landlord is part of the criminal enterprise, as opposed to just knowing about a criminal enterprise before you treat them as a criminal.
So I mean, let's say that the distant landlord receives information from their tenant that somebody is selling drugs. That landlord then calls the police and they say, hey, all the information I have is somebody in my apartment building is selling drugs. I'm going to see what I can do through the civil court system to try to evict them. They're still taking the steps to at least try within that framework to stop that, right?
Under what basis?
What do you mean?
Like, you have to have evidence. You can't just go to court, some guy told me that somebody's selling drugs in my apartment.
Right, but my point is that they're making an effort to at least try, instead of saying, I don't care, I'm a reckless landlord, and disregarding the situation.
Try when you have no legal basis to do anything. I mean, you've got to have, there's, as you might know, Rule 11 is the rule of civil procedures that prevents you from knowingly filing frivolous actions. And it's not just frivolous as a matter of law, but it's frivolous as a matter of fact. You don't have the facts to support your claim. I mean, there are things that we generally know, right? because people talk to us about it, we find those people to be credible. But that is not evidence in court. At best, it's hearsay that we can't do anything with. And if some guy came to me as a lawyer and said, "Hey, I want this person evicted because they're selling drugs in my apartment," right? I said, "What proof do you have?" Some guy told me. That's not gonna wash. I tell him, "Go away. I don't care how much money you want to spend on me, because I couldn't get by Rule 11 on that kind of claim."
So picking up on the same thread, I'm looking at the definition of reckless, and it says consciously disregarding. So there's an aspect of knowing here as well, or being conscious of something enough to disregard it. And I take your point, Matt, about evidence. When we did the walkthrough, we talked about this section as needing to be underpinned by evidence of some kind. And the example that was used was complaints that have been submitted from other people in the building. So I'm wondering if, let's take the 10-person apartment building, if you had 7 complaints that had been, I don't know, that were verifiable in some way, is that not evidence that the landlord should be making some effort, whether it's ultimately successful or not? Is it your opinion that there's just nothing that can be done if you don't have evidence that there are actual drugs being sold? You can't take any of that situational evidence that other people are supplying by personal testimony?
It all depends on the facts.
Yeah.
I mean, if the other tenant said, "Yeah, they're selling drugs out of apartment 1," they came to me and tried to sell me drugs, that's direct evidence. If they said they actually, they've been threatening the rest of us, then you're talking about interference with, to the right to quiet enjoyment of premises, which is part of the landlord-tenant law. It also deals with, kind of the illegality issue. It all depends on the facts, but it is a high, it's a high bar.
And I do take the point about it being tough to prove. I think the bill is leaning forward in that area, trying to find a purchase for a certain set of situations that currently there's no redress. And I take your point about the limit case being, that a judge just says you have nothing, we're throwing this out as frivolous, but it's.
Well, you don't want that to happen as a lawyer.
No, I understand.
Because that's an ethical violation.
Yeah. But what I'm saying is I can imagine situations where there is some sort of actionable evidence.
There are times when it's provable, but what you have to think about here is, how does a landlord, when the landlord looks at this statute, which they won't, by the way. So, you're going to catch people up in the criminal law. What is it about the act that's going on? What is reasonable for them to believe and think, given like the general knowledge base? Ignorance of the law is not a defense, of course, but we also want to be reasonable about what type of response people are going to give to situations that are presented to them. Absent, like this direct evidence of a sale, or maybe more than one sale, or threats, I think all of those things are actionable now under criminal law. And if you went to law enforcement, they could do something about it.
I understand where you're coming from, Matt, but I still wonder. The scenario that I was talking about, you have 9 tenants living in fear and 1 tenant creating the problems, and the landlord does nothing. To me, that's reckless. Maybe the landlord knows, but should have known. Maybe we can reword this thing, but I do think it's a problem, and not just in Bennington, but other places in the state where this activity is going on, and others given the housing shortage and so forth, I'm willing to, I think we'll continue to look at this, but I appreciate your concern.
Yeah, I mean,
Maybe we should
I'm
just
always
look at the recklessly.
always concerned about third-party criminal liability for somebody who is not the actual wrongdoer. That's a major problem from, conceptually for me. Putting a burden on somebody who has no general redress and no duty to act in the criminal arena,
Senator Norris had a question.
So, Matt, notwithstanding everything we've discussed as far as the probable cause and so on and so forth, I've come across individuals during my career who probably wouldn't know a drug deal if they'd been in the butt.
Yeah.
Okay. So, in looking at this, as simplified as it is, and vague as it is also, so knowingly or recklessly, so if someone comes to me as a landlord, I pick the phone up, call the police. Does that relieve him or her of their responsibility at that point in time? They took action, right?
It may.
Because they have nothing to go by besides Matt Larry just told me that they're dealing drugs. No, that's not good. I'm gonna call the police. I've done that. So does that relieve me of any?
I think so.
It's a lot closer than trying to evict someone with no proof
Well,
of evidence.
the interesting thing is oftentimes law enforcement knows that there's drug dealers.
Right. But just looking at the landlord in particular.
Yeah, well, I don't understand why we're going after the landlord.
I don't either, but I mean, just looking at that.
Unless they are complicit in the activity.
Right.
If they are running this house and, and they're charging exorbitant rent. So as a result, they're profiting from the drug sales.
But we have a witness later that'll describe some of the situations.
I'm sure there are plenty that are out there that are heinous.
I think, if I can interject real quick, I think, to that point, it is the complicit landlords that I think this provision is trying to address, that the landlord who is either distant or local and finds out this information, calls the cops. They've tried to do something to prevent this, but the landlord who doesn't care or is involved, that's a different category.
Later on, we're going to hear from the town manager at Bennington. I think he can explain a little bit of where this came from. But Matt, if you want to continue on.
The other portions of the bill, it's gun related. Well, I think it's gun related. But it's problematic to me is the issue of attaching the concept of deadly dangerous weapon while committing a felony and creating criminal liability bail liability. I think is problematic, and it's basically because of the definition of what dangerous weapon is under the law.
Page 5.
Right, you can be in possession. First of all, I keep saying deadly, dangerous weapon can pretty much be anything that is used in a manner that could cause serious bodily injury or death. This doesn't require that the dangerous weapon be used, only that it be in the possession of somebody. So in the portion of the bill that talks about carrying a dangerous weapon or deadly weapon while committing a felony, can be considered a violent act for purposes of determining bail. Somebody who gets a DUI 3 with no accident, who's carrying a hunting knife on their belt, is that somebody who's carrying a dangerous weapon while committing a felony? And that's going to be considered for the purposes of bail.
But it's going to be in a dwelling, right? So DUI is not going to.
In the dwelling?
Yeah, look on line 4, page 5.
I think danger, well, somebody who commits an unlawful trespass in a dwelling.
But that's different than a DUI.
Well, the point is that the point is that however it's applied, the point is that when you add the concept of dangerous weapon as opposed to, and it's not used as part of the criminal activity, it's not relevant. How many of us, I don't know about you, but aside from coming to the State House because I'm not wearing a belt, I almost always have a knife on me, just as a matter of a tool. And I've probably been carrying one since I was like a little kid. I wouldn't want to get, kids who are involved in, breaking into a gym or going, partying in some vacant building or doing, something that would be a burglary felony, who happen to have, a knife on them, have enhanced issues to deal with because of that.
I think it's a point well taken. Maybe it should have been firearms.
Well, I think isn't that what you're trying to get at?
Yes.
And so, that would be my suggestion there.
There may have been some confusion about which statute was being referred to here. I thought Matt was talking about bailability issue.
Yeah.
For the crime of carrying a dangerous weapon while committing a felony. That's section 7 on page 8. I think that's what I think Matt was referring to. And so that's the language that lines 15 through 17. Just so the committee knows what it is, the issue that I think is trying to be discussed here. It wasn't to do with the dwelling section in section 5. I see, okay. If I'm wrong, correct me, Matt, but I think.
Well, I was talking about availability, so I was talking about the consequences of, some. I'm worried about people who just generally carry something that could be, even on its face, a knife or people can carry firearms. Nothing against that, but whatever it is that they might be carrying that would just obviously be part of, maybe considered a dangerous weapon, and under the law, a dangerous weapon could be almost anything.
And I think I'm as one sponsor, looking at this again, and definitely the intent was firearms.
I'm at a little bit of a loss, and I didn't want to actually go into the details of this today. I wanted to kind of put forward the structure of how we would hope to deal with it. But I have not, and I'll have a little chat with her today about it, but I have not seen the administration's
Now posted on the committee webpage.
What, as of now?
Yeah.
As soon as I got from Eric about an hour ago.
Okay, well, I hard for me to say anything about that at this point, and I'm looking forward to doing that.
Well, on Friday, we'll try to accommodate various voices on the administration proposal. Right now, we're trying to just prefer to stick with what we've got in front of us.
Can I just ask you a question? I know you have another person in your office who's dealing with the firearms side of things, but regarding straw purchasing of firearms, there was one concern I had on line 13 regarding, at the request or demand of another person. My concern is, if somebody is being demanded to make a purchase, it's not a voluntary act, and they don't have the intention to make that purchase. Would you consider that to be a problem if this were to be an?
Well, it could be a duress offense, that unfortunately is the kind of thing you'd have to prove. It's obviously an issue that opens it up wider. Does that happen a lot? I mean, I don't know the answer to that. I don't know where that's. Somebody's probably got some instance or incident that they want to talk about that would show me how that would work, or whether it was one thing that happened and it'd be nice that it didn't, but it's not widespread. You know, maybe that doesn't need to be in the bill, I don't know. You know, it's a good catch. I think there's existing defenses for it. But, you know, it's, you know, good catch. I'd like to hear more personally. I'd like to know more about what that really is about.
What section's that matter?
It's on page 6, line
Yeah, I was just trying to.
page 6. It's on section 5, straw purchasing of firearms, line 13.
Line 13. Yeah, I'd have to, honestly, I'd have to find out more about what people are trying to get out with that. So if the committee, you know, I do have our folks here, but I was getting the sense this might be a bill that would take more than today to deal with. And I know there are other witnesses who at least want to get their general positions out to the committee, so.
Are there any other questions for Mr. Valerio?
Thank you.
All right, thank you.
Are we?
I'm sorry, go ahead.
I was just going to ask if we're switching to another member from your office, or are we going to Falco?
I'm going to Falco. I want to stick with the agenda. On Friday, we can hear from Rebecca and oh my God, Marshall, I almost forgot your name.
Yeah, at some point.
I apologize, Marshall.
It's all right.
Good morning. Thank you for the committee for having me here today. For the record, my name is Falco Schilling. I'm the advocacy director of the ACLU of Vermont. I think this is the first time I've had the pleasure of testifying to this committee this session, and anticipate being able to see you all quite a bit moving forward. So I want to thank you for the opportunity to testify on this bill and share some of our the areas where we are supportive of this bill and areas of concern as well in just in the next couple of minutes, and also welcome the opportunity to comment further on the administration proposals once we've had a chance to fully review them. So I think it's helpful to start out looking at this bill in those areas where we do have some we strongly support. And I think when we're looking at sections 10 and 11, the community safety grants, those are things we're very excited to see in this piece of legislation. I think this is a very forward-thinking approach and a way to try and address some of the root causes of crime and community safety, which are a concern, and I'm sure your committee is going to be hearing about. We did have one language suggestion in terms of the scope of eligibility for communities found in section 10A on page 13. So the current language says that the grants will be available to, let me pull this up real quick, community where there's been an increase in violence associated with illegal drug use, gang activity, or human trafficking. We would ask that the committee expand the criteria for eligibility to include other factors such as lack of adequate housing, lack of mental health supports, and lack of substance abuse support. So recognizing that those lack of supports can often be, core to creating conditions that create crime. We would hope that those are things that could also be recognized within the grant making process as eligibility for those communities that would be seeking these funds. So very much support the intent, and would just hope that that those aren't limiting factors in terms of what folks are seeing as the drivers of their concerns for community safety. So very much support that section of the bill, appreciate its inclusion here, understand that appropriation would have to go through other committees and get support in other places, but would be happy to support that in any way that we can. We think this is a very forward-looking approach and appreciate the committees including that in this bill. As it relates to the rest of the bill, I think just a high level, something at a higher level you'll hear from the ACLU throughout the rest of this, discussion of this bill and discussion of many other bills, is as a matter of course, we are not supportive of increased criminal penalties and incarceration time as a way to deter future crime. And I'm just going to read a short few sentences from a handout from the U.S. Department of Justice and National Institute of Justice. It's called 5 Things about Deterrence. And one of their points, one of the 5 points, point number 4, is increasing the severity of punishment does little to deter crimes. Laws and policies designed to deter crimes by focusing mainly on increasing the severity of punishment are ineffective partially because criminals know little about the sanctions or specific crimes. More severe punishments that chasten individuals convicted of crimes and prisons exacerbate recidivism. So I think generally this is something you will hear from us in many areas where we're not supportive of increasing penalties or criminalization as a means to deterrence. And so I think there's a number of places where that is found throughout the bill. I'm not going to dive into each and every single one of them. But I would like to highlight a couple of areas of concern, our highest level of concern with the language in this bill. And I appreciate the Defender General because he touched on both of them before I was able to get up here. So I think as we look at sections 2 and 3, with the increased penalties and liability for landlords for either knowingly or now including recklessly allowing their dwellings to be used to be where criminal activity is permitted. We support all the concerns raised by the Defender General. And another concern that I would like to raise is what impact this might have on folks, especially landlords, if they do know about this change in liability. We're looking at, from a financial standpoint, a change in liability from $1,000 to $100,000, which is a very significant increase, an increase from 2 years to 5 years of possible prison time. And a concern that we have is what chilling effect this could have on the ability of people from traditionally marginalized groups to actually get housing. I can see it as a real concern that landlords, if they know about this increased liability, they might act in ways that are discriminatory against groups that they might believe, would be engaged in these type of activities and not rent to them in the first place. And based off of inaccurate stereotypes. So this is something that I think is of a concern based on all the reasons you heard from the Defender General, but also the unintended consequences that could come from this as landlords learn that there is this vastly increased liability and how they might react to that, because we know that racial discrimination is a concern in our housing markets now. And that as we move forward, I would be concerned that this could have an impact on decisions that landlords might make about what tenants they were going to be renting to in the first place, based off of stereotypes that they might have of who might be engaging in criminal activity, and especially if those people are parts of traditionally marginalized groups. The other point that I'd like to, other area of concern in the bill that I'd like to point to, the Defender General also raised, and this is looking at the determination that acts that are not necessarily violent be considered violent acts for the purposes of bail. So then when we're looking at this would be sections 4, 5, and 7, especially at a point where we now have a pretty significant backlog in the number of people being held pre-trial. This is a concern because as we look at a number of these acts, they are not by themselves actually violent. And so therefore saying that the determination should be considered that these acts are in fact violent is something that we're not supportive and are concerned about. So, I think those are the main sections that, speaking to some of the issues that the Defender General raised about the possibility of carrying a dangerous weapon while committing another felony, or the possession of a firearm with a defaced serial number, or a straw purchase. These activities in themselves are not inherently violent, and we do not believe that they should be considered violent for the purposes of bail, especially when we're seeing such an uptick in the number of people being held pre-trial. So I will leave it at that for now. I'm looking forward to reviewing the administration's proposals, but wanted to highlight the areas where we are in strong agreement, but also the areas of greatest concern within this piece of legislation. And I'd be happy to take any questions.
Falco, thanks for your testimony. I do appreciate it. I was wondering if you could share your opinion on section 8, which also starts on page 8.
Section 8 is, sorry, let me page to the bill. possession of semi-automatic weapons by a person under the age of 21 years old. So generally, I think we are not opposed to limiting the number, the people who can have access to certain types of firearms. I think that this is in itself, I can't speak right now to the constitutionality of this type of provision in terms of limiting access to firearms at this point in time. I know the Defender General is hoping to bring someone forward to discuss it. I understand the intent behind this, especially with the violence that we have seen in school settings, especially by younger people. But I don't think I can speak to the constitutionality of this at this point in time, because I know that is something that is in flux, and I just can't speak to that today, unfortunately.
I think it's going to be difficult for anybody to speak to the constitutionality of many of these provisions that we're going to see regarding firearms, given the Braun decision. We're going to do our best to better understand Braun, and to, as the session winds through. So if you have experts, I use that term lightly, who might be able to help us, that's always welcome.
Yeah,
and I know of people who might be able to speak to that. I think, you could carry the idea of looking at a historical context to the idea that it'd be okay to carry loaded firearms on trains and planes, since according to all the Westerns I watched growing up, you could carry them on stagecoaches.
Yeah, and I appreciate that. And I do think it's worth noting that with the change, with the decisions that have been handed down by the Supreme Court, there's a number of areas in which this legislature is going to have to be wading into somewhat uncharted waters, where our legal landscape has changed in a number of different areas, requiring some of that thoughtful consideration about what can move forward. So happy to provide more information if we can on that, if there's specific questions, but I just not ready to opine on the constitutionality today.
There may be some information that comes through to you as a national organization that always be helpful.
You guys have any questions?
Not for Falco.
Thank you, Falco. Appreciate your testimony.
Yeah, thank you so much. And thank you for having me in today.
You're welcome. We're scheduled to take a break until 10:30. Is that okay?